Welcome back for an ideas-packed afternoon. I'm Peter Kanowski. I'm the Professor of Forestry here at ANU, Master of University House, and also Coordinator of the ANU's participation in the Australia-Indonesia Centre. And I acknowledge various colleagues from that centre and its collaborators here this afternoon. I want to begin by congratulating the Indonesia project and John and Kathy as conveners of this year's update for another outstanding event. As always, for assembling such an outstanding group of scholars to focus on issues that are central to Indonesia's identity and development. And this afternoon we're shifting from that very impressive general political and economic update to the specific focus of this 2015 update, land and development. It's a great privilege to chair the session in which we'll hear from our conference keynote speakers, Professor Nancy Peluso, who will focus on land and people, and Dr. Adriaan Bedner, who will focus on land, law and society, and in doing so frame the sessions that follow for the rest of the afternoon and tomorrow morning. So I welcome them to our beautiful, livable city, full of political intrigue and spring weather. And I thank them for making the journey from Berkeley and Leiden, respectively. I imagine that to this audience, Nancy and Adriaan are very well known already for their work in Indonesia. Very brief introductions from me. Nancy's Professor in Forest Policy at the College of Natural Resources at the University of California, Berkeley. She's been working on the political economy of Indonesia's forests and the role of forests in the livelihoods of communities and smallholders for more than 30 years. Over that period, she's conducted and written some of the definitive work on that topic, drawing on intensive field research in particularly Kalimantan and Java. And her work, as you know, also explores linkages between territoriality and violence, drawing on experience from West Kalimantan, and she's also expanding her work to a more comparative focus across Southeast Asia. Our second keynote speaker, Adriaan Bedner, brings a complementary perspective. He's Senior Lecturer in the Faculty of Law at Leiden University. He's also been working for an equivalent period, I think, to Nancy, on Indonesia's governance, law and justice systems and the interaction with Indonesian society. You can see that academic work keeps you young, just from looking at these two keynote speakers. And like Nancy in her realm, Adriaan's a global authority in his arena with an array of definitive published work on those topics. And he too is exactly the right person to be talking to us to set the stage for what follows. So I'll welcome Nancy first, then I'll welcome Adriaan. They'll present their presentations and leave us a little time for discussion. Please join me in welcoming Nancy Peluso.
Thanks, Peter, for a really nice introduction. And I also want to thank Kathy and John for inviting me here. It is such an honor to be here. Getting all choked up. There are so many people that I knew in Indonesia and elsewhere that I've worked with from Australia for so many years. It's just really is a big honor to be here and to be invited to speak. So I'm going to talk about, falling off my stool. Struggles over land and labor control in Indonesia, okay? And I think that across Indonesia, land is undergoing radical transformations, probably more extensively and intensively than ever experienced in the country's national history. Those who work the land, use the land, control the land, and or benefit from the land are also experiencing radical transformations in their lives and livelihoods. Now, much of that change is not really new. Neoliberal-era plantations have expanded from sites where state enterprise plantations used to be, and Exxon, Freeport, and Newmont have been joined by all manner of bauxite, coal, and iron-seeking corporate giants and other 21st century prospectors. Different parts of Indonesia, Java, and Kalimantan, for example, have been influenced by development in different ways in the last 20 years, because of different initial conditions in social and political economic histories and environmental contexts. But all are part of similar rapacious land-eating approaches of industrial development. Now, in the midst of this, smallholders, no longer peasants, have persisted and been remade as smallholder entrepreneurs and laborers. They compete with corporate interests on constantly and literally remade terrains that I call frontier territories, at least for the remainder of this talk. And the ones that I meet buy into some version of the development dream. And some have succeeded, as we see when we drive through almost any high mountain village in Java, or certain neighborhoods in Singkawang or streets in Pontianak, or other administrative cities and towns where beautiful houses pop up on the landscape of older wooden, brick, or bamboo structures. These are no longer just the houses of officials and the rich. They are the houses built by workers and small entrepreneurs who have gone to Hong Kong, Singapore, or Taiwan, or the Middle East, and many who have been to the small-scale gold mines of Kalimantan. So today, land transformations on the West Kalimantan landscape will provide my examples. I'm going to compare two parts of these landscapes, oil palm and smallholder gold mining, through their land uses and environmental effects, their property relations, and their forms of territorial power. Now, the last 3 decades have seen the plantationization of West Kalimantan. It took a while to get going. It's taken different forms over time, but the process is now in full swing. Plantations have brought massive changes in land use, property relations, and territorialized governance, and the social organization of working landscapes, not to mention transformations of the island's great forests and agroforests. Now, coming up quickly on the transformations caused by plantations is the allocation of land for industrial mining. I'm not talking much about this today, but many concessions for exploration and exploitation by mining companies have been allocated. And contemporary smallholder gold mining came into this context since about 1988, and its development at times has preceded, paralleled, or competed for land with new plantations. But oil palm did not begin the plantationization process in parts of western West Kalimantan where I work. And as we will see, this is an area where state rubber plantations began the land use revolution after the dust had settled from the agrarian violence of the 1960s and the early 1970s. Now, I want to remind people here about the extent of forest and agroforest that covered West Kalimantan, although this slide does not show enough agroforest in my view. It's as close to baseline data, I think, as we will get. Forest cover represents changes in not only vegetation, but also in patterns of use, claim, and governance under totally different land use regimes in totally different agrarian environments. This doesn't mean that it was a happy time with all this forest. There were plenty of contestations over power and property right in earlier days as well. Now, I think about capitalist transformations of these forests and of the land through this notion of frontier territorialities or frontier territories, which I see as competing forms of territorial capitalism in resource commodity frontiers. They make it their business to constantly recreate both the idea of the frontier and frontier conditions. Now, I remind you that the notion of frontier does a great deal of political work, okay? And what we're looking at is no less than a struggle over the shapes and cultures of production on the land in Indonesia. In particular, the history of Kalimantan is that of an island that's been made and remade in the image of a frontier by state regimes, by extractive and protective organizations, and by individual actors. Yet on these frontiers, territorial productions are also entrained through struggles over the organizational and institutional forms of extraction and production. Frontier territories are sites where space is made governable and controlled by coalitions of actors and not only state actors. And it is at the sites of these frontier territories of claiming, controlling, cooperating, dividing the product, and governing through very entangled legalities and illegalities, as well as violence, that memories and experiences of the past and the potentialities of the present clash over access to the land. So, what is replacing the forest in the frontier territories of West Kalimantan today? Work by West Kalimantan NGOs shows that 91% of West Kalimantan's land has been taken from the legal purview of the province's smallholders and others residents and allocated for industrial use. 36% is in oil palm, 37% is in mining concessions with formal permits for exploitation and exploration, and 27% is in industrial forest concessions, logging and plantation production of pulp and other forest products. So let's see what this looks like in terms of property rights on a map. So let's just start with this as kind of a baseline of data of what today's political forests cover with, of course, these different kinds of forest land uses. This is what it looks like when you add oil palm concessions to the mix. And this is what it looks like when you add mining concessions. Okay? Now you have to keep in mind that some of these concessions are only for exploration and some will never be realized, but they still show us a great deal about what happened to the forest, basically. And the other thing is that there's so much overlap between these different kinds of land uses that have concessions, and this just shows how mining overlaps with forest plantations, with logging concessions, and with oil palm concessions as well. So, what is not on these maps are smallholder territories, agrarian forests, or mining. No map of that yet. All kinds of illegal mining, not only the small-scale gold mining that I've been studying, but others as well, is going on in addition to that which has been authorized by the central and regional government. This is what smallholder territories look like in mining areas. Okay? It's not a concession, but it's a series of small mines along a river system in an area that was burned over by the forest fires in 1997. You can see the telltale signs of plantations on both sides of this of this photo. This is a mining site that's in peri-urban Singkawang. Okay, Singkawang is the second largest city in West Kalimantan. The lake in the upper left-hand corner here is actually within the city limits of Singkawang, and the dark green parts on this photo are low hills that are covered in largely Dayak agroforests, and the dark brownish green parts are swamp. The white is all mined and still being mined by smallholders. So you can see that there are complex relationships on the land visible by examining land uses, and that land use is very relevant to notions of power and property right. Okay, so one of my arguments today is just that land use is an important component of understanding power relations on the land, property and territory, etc. And in today's West Kalimantan, I would say that oil palm plantations and small-scale gold mining are most in tension. The tensions derive from very big differences in forms of property rights and access to the land, the social relationships that create localized territorial power, and differently organized land uses and labor relations. Now, but I can't do the Indonesia update thing of only talking about the last year, because so much of this has to do with history. Okay, and so I'm going to just step back for a moment and risk running over time by going back in time and thinking about other moments of broad agrarian change and what happened during those brief periods. And people don't necessarily always know everything there is to know about Kalimantan agrarian history. So in any way, bear with me. Kalimantan's first big agrarian transformation was in the mid-18th century, and it came about through what we might call a smallholder path. In the middle of that century, tens of thousands of migrants came from China, legally, came to China looking for gold. Many of them became settlers, married Dayak women, and mined and farmed with thousands more short-term migrant Chinese men. They transformed the lowland swamp forest of the region around Montrado, Mandor, and other places that are interior to today's Singkawang. Their physical impacts on the landscape, their land uses, were more transformative than Swidden agroforestry was in this area, and it made permanent changes in the land as they developed extensive systems of sawa, wet rice fields, to support themselves in the course of working in the gold mines that they also developed. Small settlements of Swiddeners lived in the hills and made Swidden agroforests, another part of the transitioning landscape, but had a much smaller impact on transition than the lowland rice farms and mines. And in part, the dynamic derives from environment and political factors because the swamp forests and peat lands were not attractive to the upland farmers and had been largely unused when the Chinese showed up. They had territorial governance here. They had property rights. They had different kinds of federations of kongsis with territories, okay? So from this very brief little 100 histories of Kalimantan, 100 years of Kalimantan history in 5 minutes, we see that gold is not a new commodity in Kalimantan, and it's not new to have smallholder production of gold. Smallholder gold mining, in fact, was what opened Western Kalimantan to capitalism. Now, that was before the onset of plantations, and the empirics of this, of course, have been documented in great detail by some wonderful historians, but as a longue durée view of the agrarian landscape and how it has changed, it has not been particularly theorized. Now, this 18th century international gold rush generated the first major agrarian transformation in Kalimantan, with all its changes in land use, changes in property relations and labor arrangements, and changes in territorial control. The next big transformation in land use, land rights, and territorial control starts with agrarian violence, as is usually the case when people's livelihoods are being challenged. The expanding Netherlands East Indies colonial state grew tired of waiting for Chinese to recognize the Netherlands Indies Authority and attacked the Chinese and their Dayak families in these gold mining and farming districts in 1850 to 1854. These 4 years were called the Montrado War, a period in which Javanese and Maoris soldiers were brought in by the Dutch, and Chinese eventually lost control of their mines and their territorial authority. And I just have to say that I'm using Chinese in a very broad way. The ethnic mix here was so completely different than these labels lead us to believe that I can't go into that, and I'm just using it as a placeholder. The important thing to what I'm talking about today is that a completely different system for managing and owning land was put into place that most of you are probably familiar with. And the label of Chinese, including those descended from many generations of Dayak mothers and grandmothers, were excluded from the racialized categories of access to land by rights accorded to native landholders. Now, about half the regional population was estimated to have stayed after the Montrado Wars and changed their major smallholder commodity productions to agriculture. They succeeded wildly in increasing pepper, gambir, and coconut production, and they were in the front lines when the rubber revolution came to what's now West Kalimantan. They competed then also with large landholders, as the Dutch, of course, sponsored or facilitated various forms of plantation agriculture, especially for rubber, but these plantations also lost out to smallholder farmers. The next really big moment of agrarian violence and transformation, of course, there were bits and pieces here and there, but this was initiated by the rising Suharto state. Chinese were evicted from rural areas in 1967, through what was called demonstrasi. The evictions took place both violently and fairly non-violently, some by mobilized local people, including Dayaks, Maoris, and Malays who were local, some in the most interior settlements by RPKAD and other special forces or army and military people. This was the West Kalimantan iteration of the National Agrarian Wars. It's gotten some attention, but not in terms of its agrarian effects. Its transformative effects have not been really talked about. Hilmar Farid, of course, has called it nationally the original sin of the Suharto government. Again, no time to go into this here, but let me say what happened around this time, and its aftermath is still poorly understood, except for a few experts in West Kalimantan recent history. Transmigration, for example, did not immediately come into the area. Okay? Transmigrants did not begin being settled in these areas of Sambas and Singkawang and what is now Bengkayang until the early mid-1980s. So what was going on between 1968 and 1983 still remains somewhat of a mystery, at least in the literature. Now, for one thing, components of the Suharto government and members of the army were physically rearranging people and space by sponsoring and in some places creating a massive internal migration. They did this by making local pribumi into local migrants. It happened in a variety of ways. In some places, RPKAD recruited people to move into new spaces left behind by Chinese, and those accused being Chinese. Chinese, of course, being the proxy word for communists in this situation, although we know that many of the Chinese were not even involved in any of the communist organizations. And in some areas, people who had been primed by army intelligence had already claimed Chinese houses and lands. In other areas, groups of Malays and Maoris traveled to request sawah and rubber gardens and houses from newly selected village heads or occupying troops. This movement then was onto the abandoned Chinese land. It involved Dayaks, Malays, Javanese, Maoris, and again, these labels are very difficult to use. And what I also realized in collecting oral histories about this in my recent fieldwork was that newly formed villages were established and formalized before the bulk of Indonesian villages were reorganized in 1979. So all this happened in the late 60s and early 70s, well before the landscape was rearranged as spaces for transmigration. Transmigration, as you know, was developed as a plantation-based system. In this region, it was rubber. Further in the interior, it was oil palm. And it was in the vicinity of these transmigration sites, once again occupied by Chinese miners and farmers and their Dayak wives, that gold was rediscovered when new technology and the world price made it possible. The emergent territory of gold mining was thus up against an earlier participant in the plantationization of the region, the state rubber plantation of PTP 12, or state plantation number 12, Monde section, Montrado, and Kinande. And what about the ethnic violence of 1997? Okay, did not involve complaints against the rubber plantation, nor did either side target the Javanese and Sundanese workers and managers who were working the nucleus part of those estates. But the violence did put a nail in the coffin of the faltering PTP. Sundanese managers and rubber tappers in those nucleus areas ran away, and most of the tappers never came back. The plantation also went bankrupt in 1997, and the plasma smallholder farmers working in the plantation plots continued to do so until very recently, when the rubber in their trees has been running out and they were able to get private titles to their land. Smallholder miners were already working some rediscovered sites of gold at this time using new technology. They competed for land and for legal recognition and territorial controls with the only industrial mining corporation to come into this area, which failed to ever hire local people, and so they caused it to fail by burning its warehouse and some vehicles. It left not long after that. And after this ethnic violence, people with capital, entrepreneurs, mine workers, crews of family, friends, and acquaintances traveled from Singkawang area to Ketapang in the south, where gold had been discovered in a very new place to seek their fortunes. So let's step back again. We'll go back to the present and talk about oil palm production as a frontier territoriality. And this means that it has both legal and illegal forms of land acquisition and uses of space. Now, with the arrival of oil palm, like any new frontier commodity, we see both the production and destruction of space, the production and destruction of property and territory, and the making of property and territory, in part through an exclusive land use. Formal land rights, of course, are given out by the Ministry of Forestry and other national institutions. District institutions produce concession rights, and there are plantation rights also given out. National institutions give out concession rights, and district institutions give out plantation rights. The former farmer's share is an imaginary average hectare on the plantation. New schemes negate all farmer and land claims and rights during production if there are new expenses also, like new roads or factories to be built. These get added onto the farmer's debt, which he or she is not regularly informed about, especially in writing. The product of the land does not pass through the hands of the farmer and the shareholder, or the farmer's shareholder. Once the trees produce palm fruit, the company uses hired workers to harvest, and all the fruit goes into a single place. The company calculates its profits from the harvest and sale and subtracts its costs, then calculates the shares of the farmers or shareholders on an average hectare basis. This calculation is also not transparent. Its components are never revealed to the shareholders, nor do they have any say. I've never met a plantation farmer who has received a letter of agreement about the terms of the transfer of their land from the company or a copy of the agreements that they signed. In fact, many landowners don't even understand whether their land has been sold or rented out. Farmers say that they sell the land, but what is actually happening is a one-time financial transaction in which they give up rights to use the land for the duration of the contract, which is 25, 35, or sometimes 60 years. It's a long-term rental, but rent is paid only once at the beginning. Labor is also completely alienated. The plantation hires workers as a separate process from acquiring smallholders' land, although shareholders can ask for work. Shareholders do not work on plots of land that are their own. They work on the plantation wherever they are assigned, a process which they bemoan as becoming coolies on their own land. And I cannot tell you how many times in 3 months wandering around, most recently, I heard that phrase. It is what people most fear and most dislike about the entire process that has been imposed. Now, these social relations around land and labor form the context of a changing set of meanings and practices on the land. Of course, there's resistance to this, as farmers realize what actually they have given up or taken away from them. And many people have documented the extensive resistance. Many people here are aware of all of this and have written a whole lot more and know a whole lot more about this than I do. But I think the thing that I really want to emphasize here, because it influences how I think about small-scale gold mining, is that the plantation's broad control of the land so physically, visually, and conceptually alienates the farmer from his or her land. It literally depersonalizes the land, that it also sows the seeds of its own destruction. Violent resistance, in fact, becomes easier. No one knows whose land is being attacked because it's all plantation land. And in fact, I see some of the enthusiasm for gold mining as a response to this major transformation in power, property right, land use, and land control. Now, I gotta tell you, as an agrarian studies person, this landscape looks horrific. It's bad. Why do people choose to go do this work over working, picking palm fruit? Well, it's complex. And smallholder miners' means of access to land, property regimes, and territorial governance institutions, at least in West Kalimantan, lead to very different kinds of frontier territorialities. They compete with and they create tensions between smallholder mining and largeholder plantation productions. And mining's obvious differences in land use involve the seeking of value below the ground rather than above the ground. Most surprising to me in my recent research among gold miners was finding that land scarcity did not drive the decision to engage in gold mining. Okay? Every Dayak mining laborer, crew boss, or entrepreneur that we interviewed told us that they owned or had easy access to at least several hectares of land. Most of them came from farm families, some of whom had 2, 3, 4, 10 hectares of land. So why? Well, they're seeking cash and surplus and a different type of work than farming, some of them. Mining crews are organized around a dredge group. They're managed by this is like 7 to 10 people, maybe 5 to 8 people, depends on the size of the dredge that they're working with. It's managed by a crew boss who technically works by himself or for himself, with or without loans from a financier. The crew boss bears most of the risks. And in mining, they can either be smallholders as crew bosses or work with them. They get shares of what is found. There is a lot of mobility from people who start out holding hoses in the pit and move up to being crew bosses of their own, okay? And they don't work on Sundays. It's amazing the number of raids on small-scale mining sites happen on Sunday, when all it takes is one visit on a Sunday to realize that they're not working on that day. Rubber plate prices have in fact gone through the floor, as you know, and as we heard again this morning. Rice prices have risen. The rupiah was losing value even before the Chinese stock market crisis. So mining is now a preferred form of off-farm labor for those that are still engaged in it, or simply an occupation preferred to farming. Okay. So smallholders and their crews narrate the labor and property relations as more equitable or fair than the plantation alternative, even though they are enmeshed in a shadow world of entangled legalities and illegalities. Miners, the digging crews, are called and consider themselves karyawan, employees, not coolies. This is a huge difference. It's not either slave labor or bound labor, far from it, and despite what some of the photos look like. As gold becomes generally more scarce and more difficult to get with the current technologies, the power of labor to negotiate also comes into view as the terms of work and pay are adjusted in their favor. Mining takes place on all kinds of land, private, collective, government, corporate land, with similar structures of property claims within the mining community, even on land with different kinds of status. So, for example, the claimants of the mines are called tuan tanah. Now, this is a strange term. It has no history in West Kalimantan, as far as I know. It is basically a feudal era term that had meaning in Java and Sumatra and other places, not in West Kalimantan. But although I only hear it in gold mining, the only thing I can think is that it's because the land was not their ancestors' land or their ancestors' traditional property. The claimant is a landlord, a tuan tanah, but not one with a traditional authority. It's a new authority, and I'm guessing that the term is used instead of pemilik tanah, or landowner or holder, because most everyone in some of these mining sites are new claimants, particularly new migrants, particularly where the mines are. Remember, many of these mines occupy abandoned Chinese land that was redistributed after violence, but does not have the power of adat claims behind them. Access fees and land rental fees are paid every month per dredge crew, plus once upon first entry. Some go to the tuan tanah, some go to the village, some go to the adat leaders, some go to the kecamatan officials or kabupaten officials who show up and make effectively territorial claims and realizing those through taxation. Some goes to police and army visitors who come quite frequently. Village and hamlet leaders generally collect such taxes monthly within the lands that are included in their village territories or claimed to be, from every mining crew, supply shop, machine repair shop, and canteen, the term for pop-up sorts of bars and food establishments that provide the company of women and sometimes more. The use of these taxes vary. Some keep them for themselves, others use it to pave or cement access roads, others use it for both. It's unfortunate, I think, that it's not only the usual culprits, the police, the army, and others who claim to be in official capacity who come and collect taxes, because it's just too often that village leaders and adat leaders come and take part in this as well. Okay, I'm just going to very quickly give you a couple of examples of these kinds of legal and illegal entanglements, how something that's locally legal in some ways actually can be used to illegal end. In part, this is because I am trying, at least in this project and also more generally, I would encourage other people to do, just instead of just always talking generally about corruption, I think we should try to unpack what that means institutionally and understand who's where and why at what time, okay? In one village that is in this Singkawang area, the village had issued land papers to all resident households, dividing up the village's swamp territory. Okay, this was not land that was farmed or done anything in. Okay, and he gave out these letters, which was completely illegal, but it was a new property right. In another place, I witnessed a group of police, army, and kecamatan men come to a shop, sit down and drink, and collect their monthly taxes on one of the former developed sites of the ousted individual mining company. In another place, in fact, right near the lake that I showed in that early slide of Goaboma, this lake is considered village common property. Lake rights have been recently claimed by 3 tuan tanah, who are called, in fact, gangsters by other miners. They have very, very high rentals and fees. The lake is actually within the Singkawang Mayor's authority area, and foresters are also mining there as individuals, and they inform when there's going to be some kind of a raid or a visit. So in conclusion, I just have 2 more things that I want to bring in. One is the ways that profits from gold mining get reinvested in other uses and contribute to a larger spiral of agrarian transformation. The fact is that after earning money in a mine, whether in the vicinity of Montrado Singkawang or far away in Ketapang, small and medium gold miners and some diggers take their gold capital and wealth and reinvest it in other kinds of agrarian production at home, including in privately held oil palm, in rubber despite the prices drop, in fruit farms. They buy shares in new gaharu or incense wood plantations, or they build bird's nest hotels. So prudent miners diversify and legitimate their businesses, buying land and investing in a variety of small and entrepreneurial activities. And in the bounds of Singkawang, there are still new agrarian options despite the restrictions on the size of their operation because it's within this new administrative city. So plantations, for example, can't be bigger than 100 or 150 hectares, but this suits the needs of smaller scale entrepreneurs. And in the other direction, when the miners have left, palm companies come back in. They buy land from villagers in Tuan Tanah, much of which is sold twice, first to the miners and then to the oil palm companies, by the territorial villages with claims. And then these oil palm companies go back through with their giant excavators, fill in large pits, and fertilize the heck out of the oil palm trees. And they are alive. So, I guess you can use the land again. So, we've looked at this in this talk at oil palm and small-scale gold mining as two forms of frontier territories that are competing with one another. Where do the people stand in terms of their relative sovereignty? I'm going to let you decide on that. Thank you very much. And thank you, Nancy.
We're changing the technology. Have a stretch for a moment.
I think I'll manage with that.
Okay, so let's get that.
I'll just fall. Perhaps this one can...
No, okay, well, okay, this one. That's yours?
No.
Okay. Okay.
How do I switch?
Just,
Where do you want to put this stool? I imagine at the end, not
no, we just moved it out of the way. Okay. Okay. Unstretch. So let me first of all thank Nancy. Thank you, Nancy, for the long view, the broad view, and the deep insights into people and land and agrarian transformation. And let me welcome Adriaan Bedner, who, as you can see, will talk about land and land law and people integration at last and for whom. Welcome, Adriaan.
Yeah. Thank you very much, Peter. Well, let me first say how pleased I am that I was invited to speak at this occasion, which we are all very envious about in the Netherlands, that you have it. Thank you very much, John and Kathy, to invite me over. Now, I'll be speaking about Indonesian land law, integration at last and for whom. And first, a few remarks about land law. Everybody's always blaming land law in Indonesia. There's fragmentation, there's overlap, there's inconsistencies, there's dualities, there's illegalities, legalities. Land law basically is the scapegoat or perhaps the bad guy in the room creating all the problems we find today in land use in Indonesia. Now, I just want to question actually whether that we have fragmentation, overlap, inconsistencies, dualities, and so on. Asking, how bad is it? It creates legal uncertainty, that is for sure, but sometimes I would argue that legal uncertainty is not a bad thing for everyone, and I'll try to come up with some examples later on. The other question is, can you actually have a completely unified land law? And the answer is, yes, you can, but then you live either in a Marxist paradise, the end stage of the communist system, or you are in a neoliberal place, which I think presently there are none like. So I think that is something to keep in mind when we think about Indonesia. how bad is it to have not full integration. I'll speak very briefly about land law dualities, because I think you always must have dualities in land law. You never can have a single unified land law at all. The first is that you always have private and public law. Private law determining the relations between citizens among themselves and saying how they can use the land between them. But then there's always the government, which always has reasons, sometimes good reasons, sometimes bad reasons, thinking that it should actually influence the way that people use their land as well. So we need roads, we need infrastructure. Sometimes we think we need economic development, so we need to give land out to investors and remove it from smallholders, or the other way around. So there will always be government intervention in public law, spatial planning, of course, being the prime example. Then there is land administration of private land rights. That's also a very significant thing, because in most countries, including Indonesia, you find land registers which are kept by the government. Now, you can also, like in the US, you have systems where there's actually no officially kept land register, making the system pretty expensive, because you have to get an insurance for every land title that you buy to make sure that it doesn't belong to someone else. So there are good reasons, but sometimes the state may also, of course, use the land administration for its own purposes. So changing, for instance, using it to change the use of land. And finally, and this is the best known example, I think, of the duality, certainly when it comes to Indonesia, is you have state and non-state law. So there is this idea that there is a customary law, for instance, and that people arrange their land relations within their own system, and then you have the state, which has its own system next to it. Now, the problem always is, of course, that how do you delineate the two? And the other question is, what does it do to legal certainty? Now, to show you that it's not always bad to have this difference, and that actually it may be good to retain a customary or a folklore system, whatever it is. I have these two gentlemen here. Well, the good guy for you is on the right side. This was van Vollenhoven. I'm from that institute. I'm not from the other. And van Vollenhoven actually used the system of customary law to protect Indonesians from encroachment on their lands by the colonial government. Whereas Trinité, who was very much in favor of a unified land law, which actually would mean that big enterprises could not be halted in buying up Indonesian land. Now, so I'm not in the North Trinité Institute. Still, it is true that in Indonesia, many governments have embarked on the course that North Trinité actually suggested. And I'll speak this will be the shortest history ever of Indonesian land law you're going to see. So if you want to know more about it, I read a big book by Peter Burns or someone else, or you read my paper later on when it's published in the update book. The first thing I want to mention is the culture system, which was in the 19th century. And it was an interesting system for this particular reason, because it kept out Europeans from Indonesia. The idea was simply that you just left the system intact, and these people were forced, in sometimes terrible ways, to grow crops for the European market. But basically, their internal relations were left alone. They were just allowed themselves or forced themselves to arrange how they did this. Now, this completely changed with the agrarian law of 1870, which opened the possibilities for capital from European entrepreneurs and to start plantations. Now, there's a few things about the agrarian law I need to mention. The first is that there were actually systems in place to protect Indonesians from this influx. The one was the prohibition of alienation. You could not sell your land to Europeans. The other was that there was a broad recognition of adult rights, and the important thing is that the idea was that the right of avail, the communal right to actually dispose of your land, was supposed to be valid, and what was covered by that right was not supposed to be used by plantations. Well, that went wrong very quickly because the government, the Dutch administrators in place at that time thought about this differently. Now, this is a constant in Indonesian land law because this is an attitude which we see has continued. Perhaps it's all the fault of the Dutch, were the Dutch who taught the Indonesian government to act in this way. But it's always the administrators who often change the original ideas in the laws and who in their implementation do very different things than they were originally supposed to be doing. Now, with independence, the colonial system was kept in place, but the state got even broader powers to actually determine land use. And this was particularly through the famous or notorious Article 33 in the Constitution, which says that the state actually, that land has a social function and therefore can be used by the state. The state can intervene in land relations. The next one is the basic agrarian law that actually continued the system already announced by the 1945 Constitution. And it was really meant as an overall unified land law. What it actually was, many people still say it was based on Adat. Well, I'm happy to discuss it later on with you, but that's a lie. It was just a Western land system cloaked in Adat terms. It really is an individualized system which really tries to get rid of all communal lands. Although hak ulayat, the right to avail, is officially recognized, but there is no suggestion whatsoever in the law that it was actually intention to do something about that in practice. So unification of land. So the state becomes central. The state determines land use through creating uniform rights. It provides rights on land unencumbered with rights to individual citizens, but mainly to entrepreneurs. And it removed the hak ulayat in most cases. Now, the problem here was that, unlike in earlier times, there was no longer a counterweight against this executive dominance. So there was a dismantling of the courts. The courts could not really resist it because they were completely made subservient to the interests of the executive. And scholarship, which was very important in the old days, even in Indonesia, when you had scholars like Supomo, Jodi Guno, and others who were really very well versed in this field, they lost influence and could not do much to actually resist the interpretation of the state anymore. It became worse with the forestry law, which broke in actually on the unified system in a sense. Now, you probably think that you may think that I think that that's a good thing, but in this case, I am not of that opinion, because what happened actually was, on no legal basis at all, the forestry department actually took control of 70% of all of the land in Indonesia. Not actual control in all cases, as you can see when you walk into a forest in Indonesia and you see all the villages on it, etc. But still, that was the idea. The idea is actually that it is assumed that all this land is forest, that it's covered by forest. So it is an intention which is there. So the government's task, the Ministry of Forestry's task, is actually to make sure that all that land is covered by forest, and that they can therefore take their measures to ensure this. Well, you all know enough about Indonesian forest that is not really what the Ministry of Forestry is trying to do all the time. Well, then we have the spatial planning law, which was a good try to actually somehow delineate, to synchronize all these uses of land, and to make sure that that forestry land and non-forestry land and all kinds of uses were actually well attuned one to the other. Now, this was a brave attempt, I think, for the 2007 laws goes well. But again, we see here that it was in administrative processes that everything got stuck, and that no effective spatial plans were put into place. Then finally, about dispute resolution, I think this is one of the key issues which has created a very negative plurality in land law, because there is an increasing complexity in land ownership cases and jurisdictions get mixed up. And this has partly to do with the bad functioning of the courts themselves. So if you have a private ownership dispute, what you will do in many cases, you will just go to the court or to the police and you say, look, this is a case of fraud. So you get it into the criminal court. At the same time, you may address the same case in the civil law court. So what you get is, and you may even go to the administrative court to say that the land right that was actually given to you, that was given to the other party by the administration, was given in an unlawful manner. So you can have three cases about one, three court cases about one actual dispute. And this happens a lot. And it makes sure that there are often three different decisions in one case, which is not really helping to resolve the issue. Now, there are several, some of the most important problems we see are the following. So to what extent is law the cause of the problem when we look at these issues? Now, as I said, forest, non-forest land, that's not really a statutory problem. That's more a problem of sectoral policy interpretations. When we look at the position of Masyarakat Adat, we have seen that the law has been a problem here. That definitely the basic agrarian law and the forestry law to even further extent made this into a problem. Then when we look at squatters, we actually see that there is an absence of land registers that serve as full evidence, and much land has not been certified yet, has not been registered. But actually that's not much of a problem because, well, sometimes it may be, but in most cases we see that there is a rise of a semi-formal system of land registration, for instance by people using tax receipts. And in many cases this works quite well, and I would suggest to just leave it that way. I'll get to that in a minute. Then expropriation. We know it was really bad under the new order, but there have been some interesting developments about that later on. I'll skip economic development now because that takes too much time. And jurisdiction, I already mentioned that. That is a serious problem. There's also a lack of implementation of judgment, so basically you don't have, it's very little used to go to the courts. Now there's a few new developments which are interesting. First, there's a constitutional court. There's a new player there's a new kid on the block, somebody said yesterday. Well, that's the case, in this case, the constitutional court. It's for the first time a court that's really setting standards in the sense that their judgments actually make it to the newspapers. People talk about it, and sometimes they really translate it into policy rules. So, to give you an example, there was a famous case that was brought to the court in 2011 about the defining of forest land. Now, in this case, the court determined that the Ministry of Forestry violated the Constitution by considering all the land they had appointed as forest area. This, just as I said, it was actually not even, it didn't even have a legal basis. Only if the full process of gazettement had been run through a forest area under the control of the ministry, so it only became into being after it had been fully gazetted, the control of the ministry. This reduced the area, of Indonesia where the Ministry of Forestry thought to be in charge of from almost 70 to a mere 14% of Indonesia's landmass. Now, this case has driven the ministry to an unprecedented activity to make sure that they wouldn't lose all of their land. And they showed that Indonesian government institutions can be very effective when they have to. And on 4 September 2014, the ministry had indeed gazetted almost 60% of their final target. This is really incredible when you see how little they did before. The other result has been more willingness on the part of the Ministry of Forestry to strike compromises with some resource-rich provincial governments in determining how much land they would release. And I mean, I think that perhaps the in central Kalimantan, the provincial government should have taken some exercise in negotiation, because they managed to get it down from 90% forests to 82, which I think is 8%, it's a mere 8%. But anyway, it was something that they achieved. Now, the conclusion here is that the Constitutional Court, unlike the Supreme Court, has driven the government to take action, which I think is remarkable. Now, another result of this was the Joint Ministerial Regulation on Procedures for Land Claim Settlements inside forest zones. This was made by the Ministers of Forestry, National Land Agency, Public Works, and Home Affairs. And as a friend of mine said, who does research in this area, said this is history. It's never been the case that these ministries have been willing to work together. And actually, I think this is an example of where we may get to a more positive form of unification, where actually ordinary people may benefit from resolving a number of conflicts and claims and disputes, the ones Nancy was referring at as well. And that's certainly what I hope. Then the land bill is another thing. And this is another example. This has not to do with the Constitutional Court, but the land bill is a very important new initiative. It was originally devised in 2013, but it's been brought to Parliament once again. And it can bring some important changes to the original basic agrarian law. Now, first, it sets limitations to land holdings. Land rights fall due when land is not used, and it reserves the main rights to Indonesians. I mean, it's not going to say it's going to work, but at least it has some clear provisions to that extent. Then it creates clarity. So it defines the right to land, which the basic agrarian law never did, and it limits them to only 5. And it resolves important questions such as the one whether you can provide a land lease on freehold property. You can. And it also finally regulates the management right, so the hak pengelolaan, which is used widely, but nobody exactly knew what it meant. So it's good that you have some such definitions. But it's also specifically integrative, because it provides freehold property to those who, on the basis of Alat law, have an individual right to this land. And very importantly, it creates a form of adverse possession. Now, you may not all know what that is, but it simply means if you use a piece of land for a certain amount of time in good faith, and that of course is tricky, but that can be established, then you become the owner of the land. You're entitled to a land right. Now, that has been a big problem, that in Indonesia there was no form of adverse possession anymore. So that was going to be a problem. Is everything great about this bill? Well, there's 2 problems. There's 2 things, I think, which show that it has some issues. First, all land's going to be registered in 5 years. Now, they did, since the BAL was in 1960, that is some 55 years ago, or that's not going to work, 5 years. The other thing is that it suggests to establish a single land reform court in each provincial capital. Now, I think that would be disastrous, because it means that people actually can't go to the district capital anymore, but they have to travel to the provincial capital, so it will make the access to courts very bad. Now, I told you that the courts are no use, but this goes too far, I think, and you can't expect anything of the courts anymore. Besides, not going to resolve the jurisdictional problems. Now, I have no time for my conclusions. I'm well aware of that, but I'll go say a few things still, if you allow me, Peter. At the level of statutes, when we look at blaming land law, at the level of statutes there have been important attempts at integration, and much has improved, also because of the Constitutional Court. The new land bill would improve several points and reaffirm the supremacy of the basic agrarian law. So it would actually make clear that the forestry law is not standing next to the basic agrarian law, but that it is a subservient statute, so to say. The basic agrarian law is the overarching framework. A good thing is also that it would be more realistic underpinning of transforming semi-formal rights into formal rights, if you want to do that at some point. And I wouldn't do that too quickly, not in 5 years in any case. The other thing is what we see is state agencies conduct their own policies. They often go against statutory provisions, and this applies to providing land rights, spatial planning as well. And we all know why this happens. That's probably what most of the presentations following this one will be about. But I think we should really unpack that, and we should really look into the reasons. Now, law is only one argument in the debate, and it is seldom supported by an effective court. So the key is control of state agencies, and a better integrated law can only be part of control of state agencies. Now, 10-year security for whom? I already mentioned that. I think that when you totally unify system, it may be quite bad for squatters in particular, and you really have to look into mechanisms for how you can make sure that a fully unified land law and an effective land law system will not only be profitable for the conglomerates that were mentioned this morning. Now, the future of the ADAT paradigm. Here I'm in Dutch we say I'm throwing a stone into the pond. When we look at we see that this protection actually arose in the colonial times, and at that time when ADAT structures were still mostly in place, even at the end of Van Vollenhoven's life in the 1930s, there was already a lot of critique on this, and people said, you can't keep this up. I think that indeed, at present, with so much change, we have to very much reconsider whether the ADAT paradigm and the recognition of ADAT rights, whether this is the right way to go, and whether this is not excluding large groups of Indonesians who live in places like the Chinese you were mentioning and others, who are just as entitled, I think, to protection against the state to keep them in place. And I think there is a problem that Indonesia is still hanging in this ADAT paradigm, but this is something I hope we can discuss later. Now, rule of land law, is there a rule of land law? No, there is not. Yes, I'm going to stop. There's no rule of land law. Thank you very much.
Thank you very much, Adriaan, for the historical context, a very accessible and thought-provoking overview of a scarily challenging topic. 3 brief questions, 3 brief answers, and we'll move to the next session. So I'm looking around for questions, one there, and one at the back. So, Omar.
Thank you. My name is Josie Katarina from University of Melbourne. I would like...
Okay. Yeah, you're right. You're set. Yeah. Okay. Yeah, please.
Thank you for the very interesting presentation. If I may get more elaboration from Pak Adriaan about the pessimism about the ADAT paradigm. Thank you.
Thanks. Okay.
Thank you, Adriaan. My name is Omar, PhD student at Department of Anthropology, ANU. I think you've probably forgotten one new bill that was submitted to DPR, to the Parliament. I think about at the same time when the Constitutional Court rules that changes in the the Article 1 of the Forestry Law, and that is the bill on recognitions of acknowledgement and protections of other community rights, and that's by many people is seen as one of the important complementary to the Constitutional Court. And other people, commentators says that joint ministerial sort of procedures, that's weak because the same thing has been actually issued during the Kustur period, and that's according to in the law hierarchy, Indonesian law hierarchy, it's really weak. Do you think the reasons why they don't want to pass that acknowledgement and protections of other community rights is partly because they don't want the other community rights to be to be acknowledged and recognized? Thanks very much.
Thank you. And a third question up the back.
Thank you. My name is Yogi Vidyatama from University of Canberra. My question is for Nancy. The question is, I was working in the East Kalimantan in the late 90s and early 2000s. And one of the issues is those who obtain the oil palm permit actually using that as a cover-up for illegal logging. And I didn't hear that story in the West Kalimantan that you have just presented. Would you mind to have like a story whether it is happening or it is not or something like that? Thank you.
Thank you. I'll ask Adriaan to respond to the first two and Nancy to the third.
Yeah. Well, I can actually take the question in the back and the first question here together. My pessimism about Adat, it's simply that, and also about the bill of about Adat communities. I think it's usually in virtually all of these bills and regulations, one of the demands is that there is still an Adat structure in place, and that there is still, in varying degrees, there still is that a community is still governed by Adat. Now, this is very hard to actually substantiate, and it's particularly so because in many places Adat structures and state structures are mixed, and are mixed up in different ways, which will make it hard for them to pass the litmus test of whether there's still an Adat structure in place. So I think basically that many communities will not pass that test. There's another practical side to this, which has to do, and this is Willem van der Muur, who is also present here. Yeah, they're in the back. He's doing research about this. It turns out that even on the basis of the provisions that were already there, it's been extremely difficult to get recognition as an Adat community. Actually, only when people still are in control of the land can they get such recognition. That's practically the case now, so things have to really change to a large extent. And we also see movements away actually from the Adat paradigm now in the idea of the hak communal, the communal right, which doesn't no longer it says it can apply to Adat communities, but also to other communities. And I think actually that is a hopeful sign that we will perhaps go another way. To me it's hopeful because I know so many people who are not part of an Adat community and are also, I think, entitled to control over the land, which is now basically said to be forest. Then about the joint regulation. I don't think it's important that it's not at the level of a law, because I think it's even stronger because it shows the intention of these ministries. It's an indication that they seem to be willing to cooperate, and actually they already developed some activities. Now, of course, we always must see what's happening next, but I think particularly because it was a joint regulation, it was more like an MOU, that may work much better than when there is a law which says that they should do something, because generally that takes ages before the first implementing regulation is even there. Whereas this offers a basis where they can immediately start to work on. So I'm pretty hopeful about that one.
Thanks, Adriaan. Nancy?
Thanks. The question was about whether oil palm permits are a cover-up for illegal logging in West Kalimantan, or did that happen in West Kalimantan? I'm actually not sure about certain areas of West Kalimantan. I haven't really worked up along the borders where there were still a lot of forests quite recently, but that have also been turned over into oil palm plantations. Maybe John can answer this question later, or somebody else. In the areas where there's not a lot of Meranti or other kinds of timber that it has value for the illegal logging trade, maybe not. So.
And there we're going to have to leave it for the formal discussion, but there's plenty of time for discussion with Nancy and Adriaan over the next day. I'd like you to join me in thanking them again for very stimulating presentations. For such good timekeeping, and we're going to have a seamless switch over to the next session. Please stand and stretch in your seats. Don't go away. We're about to start the next session.